Be seated.
Good morning. Now is the time set for oral argument in Cause 1 CA CV 130325, New York Community versus Weber. For your information, these proceedings are being both audio and video recorded, so barring any unforeseen problems, you can critique yourself on YouTube in a couple of weeks. Counsel, each side will be entitled to 20 minutes. We would ask that you respect that time. The timer located on the podium will let you know how much time you have left. And appellant, if you wish to reserve any portion of your time for rebuttal, please let us know so we can try and avoid taking up all your time. But ultimately, your reserving of rebuttal time will be up to you. We have reviewed the briefs, we've conferenced the case, so we are well aware of the facts and issues attendant to this argument. You might want to keep that in mind in how you use your time and the things you specifically addressed to the court this morning. When you come to the podium, counsel, I'm going to ask that you state your name and who you represent. And with that, you may begin.
Again, good morning. Ellen Davis and Francis Slavin for appellant Dave R. Weber. As you know, this case arose out of a promissory note that Mr. Weber gave to Desert Hills Bank, the predecessor to New York Community Bank, in July 29, 2008. It was a demand note, and it was all due and payable in 1 year, which means at any time the bank could have called, made a demand on the note, and then resorted to the collateral. In August of 2009, the combined value of these two unfinished lots, according to appraisals from the bank's file, which was being held as collateral for the $350,000 loan, was $348,000 in the as-is condition, which means the appraiser went and looked at the property and appraised it in its as-is condition, which was the same thing for the appraiser who did the initial appraisals back in 2008 that led to the establishment of this loan in the amount of $520,000, both of them as-is appraisals. If the trustee's sale had been conducted on the date it had been noticed, under ARS Section 33814A, Dave Weber, as the defaulting borrower, would have been entitled to a fair market value of credit of $348,000 if the sale had been held as noticed.
But is that the relevant time to look at? Is it your contention that the very first notice of trustee sale was somehow a breach of the duty of good faith and fair dealing?
Judge Downey, our position is this, that a foreclosing lender, when it is exercising its rights under the statute, which grants it a broad, non-judicial power of sale. This is not a judicial officer conducting these proceedings. It's a non-judicial officer conducting the proceedings. And in exercising the power of sale, that trustee or the lender that's directing that trustee must exercise good faith in conducting those proceedings.
But my question is, I understood your argument to be that the bank's conduct in continuing the sale a number of times and doing so arguably at a time that it had no intent to foreclose was the breach. And so I'm trying to clarify, because it's important. For me, one of the issues that I'm focusing on is whether you produced competent evidence of the fact of damages, not the amount of damages. And so to determine that, I need to know at what point we need to look for your evidence of damages. And I'm trying to figure out whether you're saying the very first notice of trustee sale was a breach of the duty of good faith and fair dealing, because it sounds like you are saying that, or else the evidence you're talking about right now wouldn't be particularly relevant.
Okay. I am taking that position for this reason, that in the postponement of the sale, by the way, Your Honor, I would like to reserve 2 minutes if that's okay with the court. The relevance, in the exercise of the postponement, our position is that the lender is bound by good faith that when it exercises the postponement, it gives thought to whether or not the postponement at any way, shape, or form deprives or impairs the defaulting borrower of its fair market value credit rights.
But now I'm hearing you say that it's the postponement that's the breach, not the very first notice.
The first notice is not the breach. However, I will say this much. We went back and looked at the bank's records, and it appeared to us after the fact, after many of the postponements, that the bank did not intend to go through with the sale that it had noticed.
As of the first sale?
Yes, as of the first sale.
So you're saying that as of the time of the notice of the first sale, the email or whatever it is you found in discovery said, this collateral's worthless, we aren't interested in foreclosing it.
Right. So I think at that point in time, if they go ahead and foreclose, the statute, if you look at, let's look at the CSA case that we just gave you on Friday.
Well, Counsel, before, because I want to get back to Judge Downey's question.
Okay.
Are you saying, what I'm hearing is sort of a continuing breach in the sense that you're saying the initial notice was a breach because they never intended to foreclose, to have the sale. And then the postponements were a breach because during that entire time, they didn't intend to have the sale. Is that a fair statement of what your position is?
Judge Kessler, that's a fair statement of my position.
Now,
yes.
let's get to the fact of damages.
Right.
The problem with these appraisals, and I think that's what the judge sort of, in looking at the oral argument, seemed to be the focus of these appraisals. The problem I had with the appraisals was that none, as I understood it, none of them took into account that there was a pending notice of trustee sale.
That is correct. They're not allowed to.
All the notice of notice of trustee sale.
That's
So
correct.
all of the decline in value seems to me simply to show the economy was horrible. This community had real problems, and the property value was declining. The question then becomes, for summary judgment purposes, what evidence was there that the banks, let's just talk about the continued failure the continuances of the notice,
Okay.
and without any intent to really have the trustee sale, contributed to the decline in value. The only thing I could find, and maybe you could help me on this, was Mr. Weber's deposition testimony, where he talks about that if he tried to sell it, there would be any buyer coming in would beat the heck out of him because there wasn't enough, because they knew there was a pending trustee sale.
Yes.
Was that attached to any of the statements of fact on the motion for summary judgment before
Yes.
Judge Rice?
Yes.
It was. Okay.
No references were to Mr. Weber's deposition.
But to that particular deposition testimony, because we only consider what was before the trial court, and if
Right.
that deposition testimony that Judge Kessler just outlined wasn't specifically before Judge Reyes, we're not going to consider that as a basis for overturning his decision. So it's really important that we know that that precise deposition testimony was in front of Judge Reyes or wasn't.
And that would have been the deposition testimony, I believe, beginning around page 47 or 46 through 57. I guess we could check the statement of facts to see it, but you're saying it was attached to the statement of facts?
Well, it was referenced, but let me switch the focus for a moment from where I'm coming from, if it's okay with you, and I think I can still answer your question, sir.
Okay.
Which is this. The focus here should be on 33814A. That is what Baker v. Gardner's case says, that the purpose of 33814A is to protect the borrower from the risk that the lender will create artificial deficiencies.
Well, that's the anti-deficiency statute, right?
No, 33814A is not the anti-deficiency, it's a deficiency protection. 33814G is the anti-deficiency
Okay, go
statute.
ahead.
That applies to residences 2.5 acres or less that are utilized for residential purposes. But 33814A is the absolute target of our case here.
But
that a-
doesn't that go to whether there's a breach of the duty of good faith and fair dealing? And let's assume we get past that and say there's sufficient evidence to go to the jury on that. That doesn't address whether you have produced competent evidence of the fact of damages. And the answering brief really hammered on that. And so I was looking to the reply brief for you to show us where you establish in the record in opposing summary judgment the fact of damages attributable to the bank's conduct.
The fact of damages, as in most of these cases, Judge Downey, is frequently testified to by appraisers.
That goes to the amount. And you know, there are two components of damages, and the fact of damages has to be proven with higher precision than the amount of damages. An owner and appraiser can testify as to the amount, but the fact of damages has to be established at a higher standard and as a threshold matter. And these appraisals didn't do that for the reason you just acknowledged with Judge Kessler. They didn't tie it to the bank's conduct.
And if you look at the definition, Judge Downey, in 33814A, and if I cannot repeat that statute often enough here, I apologize to you. But if you look at the definition of fair market value in 33814A, it says that in determining fair market value for purposes of establishing the credit to be given to the defaulting borrower at the trustee's sale, you do not take into account sales under duress. So the statute itself, the state legislature said you do not take that into account. So for purposes of 33814A, the legislature gave Dave Weber a credit under that statute for the amount of the appraised value on the date of the sale. And he did not get that credit. That would have protected him from the deficiency that the bank is seeking here today. The bank said, well, we have the right to postpone no matter what happens with callous indifference to Mr. Weber's rights under 33814A. So the formula is set up in the statute itself. And so what happens is Mr. Weber is entitled to that credit on the date of the sale. Had the sale been held, he would have gotten that credit. But they kept writing it down to the point where the value kept decreasing. Had they done their foreclosure, they would have had a piece of property that they would have sold, recouped most of their loan value out of it, and moved on.
So you're saying that the phrase in 814A, assuming that neither is under duress, means that there is no, that you don't take into account any notice of trustee sale?
That is our position, yes, that you do not take into account. And so when you are out, when the appraiser is going out to come up with the sales, they don't look for forced sales. They can't look for forced sales. They have to look at market-driven, voluntary buyer and seller sales, all being aware of the market conditions that apply to the property, being free to make a judgment under those circumstances. The state legislature made it really clear. You're not going to look at the impact of the foreclosure. You give the fair market value on the date of the sale without regard to forced sales. That's what it says.
But we're looking at your affirmative claim of breach of duty of good faith and fair dealing, not the fair market value hearing under the statute. We're looking at your own claim, which requires proof of certain elements, including damages. And so I think that's conflating the two types of proceedings that are going on in this case.
If I were to go, if this goes back, if you send this back to the court, it would be my role, I believe, to go before the trial judge and say, here are the damages my client suffered. And I would bring in appraisals. How else do I do it? How else do I determine what the damage is to my client for the bank's failure to proceed to conduct the foreclosure sale when my client is protected under the statute from that reason? I've got to use appraisals. I cannot do it any other way.
Wait.
I can't do it any other way.
There was a motion for summary judgment.
Right.
How'd you do it in response to the motion for summary judgment? You have to come forward with some evidence to show your client was damaged by the continued notice the continuing notices of trustee sale without any intent to have the sale. Where in the record did you show the judge to preclude summary judgment that there was damage because of the notices? You're saying that there was these appraisals?
Yes. Here's what was before Judge Race. $348,000 appraisal near the date of the notice sale. July 2011, almost $2,000. $2,000, the property going down to $2,000 because, at least according to bank's appraisals. So during that period of time, what happened? The property kept declining in value and the bank kept postponing the sales. Continued to postpone it, realizing that all this period of time, as it kept dropping down and not holding the foreclosure sale as was noticed, that it held it to the point where it reduced to zero. Are we saying that a trustee or a lender that forecloses may postpone 13 times in 2.5 years, ride the property down to $2,000, and there's no evidence of damage?
If it was not for the recession, those damages would not have been as severe, correct?
If it hadn't been for the decline in the market, that is correct. But to point to say, well, gosh, then that wasn't the bank's fault. But the bank knew and understood, Judge Jones, that the property was going down in value. They had a $520,000 appraisal at the outset, 1-year demand note.
So that was my follow-up question to what I asked you before. It may not be atypical for a bank to continue a trustee's sale any number of times, correct?
That is correct.
Are you arguing then that the damages only arose because they knew the situation in the market and still continued it out while they knew the price was falling?
Absolutely. Absolutely.
And that is your fact of damage?
Yes, that's a fact of damage, and here's how that worked. They knew and understood that under 33814A, as they continued to let the market go down, then the fair market value credit to give to Mr. Weber was going down. So the offset, or the fair market value credit against the amount owed the bank, kept the offset kept going down so that the amount owed the bank continued to rise. We're foreclosing under the deed of trust, wherein the state legislature again says the defaulting borrower cannot be thrown to the wolves. I'm sorry, we're not going to allow that in the state of Arizona. Not going to allow that. So when you, Mr. Lender, are going to exercise your rights under this foreclosure statute, you must do it in good faith. The bank argues, listen, the statute says procedurally. Procedurally, I can postpone from time to time, and therefore that may override your client's substantive right under 33814A.
Let's assume that the statute allowing the bank to continue a trustee sale doesn't give them immunity from a bad faith claim. I've got a problem because, in essence, what 814A does is says it protects the buyer, the debtor, the borrower, from an excessive deficiency judgment because you look at the value of the property at the time of the sale.
Yes.
If there's a sale. That's what 814A does. It says don't take into effect that there's a notice to trustee sale. Just what's the fair market value at the time of the sale, and that's the actual credit. So there's not an excess deficiency judgment.
Right.
Your argument is, well, I lost that protection, right, because they never had the sale.
Correct.
So how do I protect my client? I protect my client because I say breach of the good faith and fair dealing.
Right.
Because you never intended to have the sale.
Right.
And you just continued this while the market was in free fall. Then the issue becomes, how can you point to, because there never was any sale, how can you point to what the fact of damages was because of the bank's continued notice of trustee sale? It seems to me, and getting back to what Judge Downey was saying, is there seems to me to be a difference between what the statute is saying. So if there's a sale, you're protected because the credit will be based on the fair market value without the notice of trustee sale. If there's never a sale, then you have to show that somehow the bank's failure to have the sale, but continuing the notice, created a fact of damage, depressed the value of the property, the value of the property.
Okay, I'm with you. I don't think I have to show that. I'm sorry, and we can respectfully disagree on that. If If you come upon someone who's hemorrhaging and you allow them to hemorrhage and don't help bandage the wounds, what have you done? Nothing to help. The bank has a fiduciary duty of some type here. It has a duty to exercise this power of sale in good faith. And when they never intended to ever exercise it, but what they did is they protected themselves from ever having to give Mr. Weber a fair market value determination.
But Mr. Weber could have tried to sell the property.
There would be no way this man could have sold that property. He testified to that.
Well, he didn't quite say that. He said I couldn't sell it because I wouldn't have been able to get enough money because of the notice of trustee sale. Anybody coming in to bid would have beaten the heck out of me on the price, and I wouldn't have been able to get enough money to take the bank out.
Right. So what does he do? Like any, I would think, well-informed defaulting borrower, is say, I have substantive rights the state legislature gave me under 33814A. Why do I go out and sell it at a depressed price when at the trustee sale I'm entitled to a fair market value credit established by an appraisal? That's what it provides for it. Real quickly, on the CSA case, you can't waive your rights under 33814A. What this bank basically did is, through its actions, it was the same situation. It took away the rights of Mr. Weber under 33814A, and I see I can't reserve any time. I'm out of time. Thank you very much.
Thank you, counsel.
Morning, Your Honor. Scott Reynolds for Appellee New York Community Bank. I'll just start with the CSA case. That was a case that actually, the trustee sale in that case actually did occur. The trustee sale went forward, and then there was an issue as to whether or not you could actually waive through a contract your right to a fair market hearing. So it really has no applicability to our case. I think the court has hit the nail on the head with the no fact of damages in this case. There was no presentation of actual damages in the case at all.
Well, counsel, what do you do with Mr. Weber's deposition testimony that we're alluding to earlier? Was that part of the statements of fact?
Not that I recall, Your Honor. I can't say without actually, looking through the document, but my recollection is that did not occur. I know what was cited was the very portion that you cited about him with respect to his comment about him not being able to sell the property.
So at least some of that reference was presented to the trial judge, whether the deposition testimony was attached or not. It was presented to the trial court.
That part was, Your Honor, about him not being able to.
What do we do with that? Why doesn't that show damage? I mean, if someone comes in and says, I'm the owner of the market, matter of fact, I'm a broker, in essence, hard money broker or whatever it is, and I've owned this property, and I'm saying that the continued notice of trustee sale is depressing the price of the value, because anybody that's going to come in is just going to offer almost nothing because of the notice of trustee sale. Assuming there's a breach of good faith and fair dealing, why isn't that a fact of damage?
I believe, Your Honor, that it has to be more than just, it's going to deflate, devalue the property. I think it has to be more than that.
But didn't the bank in fact know through repetitive appraisals that a piece of property that comes in and is initially valued at approximately $500,000 is on its way down to a $2,000 value, and they're sitting on it with no anticipation of completing the foreclosure in establishing a fair market value and selling the property?
Well, Your Honor, we never got to that issue.
Which issue?
What you're talking about are what did the bank know as far as going forward on the postponements, going forward, and how this property got to basically no value.
But you certainly knew the price was collapsing on $500,000 worth of collateral.
I think in general, yes, I think everybody knows in general that the market value would go down on the property. I think there was such uncertainty with the property.
But for 2.5 years you knew it was going down, and for 2.5 years you just kept extending trustees sales that you never intended on following through on.
I would disagree with that, Your Honor, that there was never any intention to proceed with the trustee sale. I think if you look at the timeline of the case.
Interrupt, because isn't that a factual issue? And we have to construe the facts and the inferences in the light most favorable to Mr. Weber. And so I'm not sure we really want to get into parsing whether the bank intended it or didn't intend it. But looking at the facts in the light most favorable, it seems to me you've got a problem there that, as a factual matter, we're not going to resolve here. Isn't that?
That's true, Your Honor. I'm not here to debate that part of it. My understanding is that we're here today on a very narrow issue of damages, and that's what we should be talking about. Based on, I'm sure you've read the transcript from Judge Reyes, how he spent an hour with us going through this in detail. And could not come up with any fact of damages in this case.
Well, and that's been my focus. And so let me get your analysis of what you believe they could or should have done to stave off summary judgment as to the fact of damages. We know that a property owner can testify about their opinion as to value. That's not the fact of damages, that's the measure of damages. And as I was talking about with Mr. Slavin, the fact of damages has to be established with higher precision than the measure of damages. So what, in your view, was he required to do to ward off summary judgment as to the fact of damages? Bring in an expert or an appraiser who could actually say, this would have been the value without foreclosure proceedings, this was the value with foreclosure proceedings, that is the fact of damage?
Exactly, Your Honor, and I think that would have been a very, and you have to wonder why that didn't happen. I would submit to the court, they're not going to be able to find anybody that's going to actually say that. Because it really truly is just the decline in the value in the market. That's the force that's, driving it. And in fact, today we know in the last 2 years, values have gone back up generally in the market. Okay, so.
And if you were to present that argument to a jury, they might agree with you, but we've got to decide whether there was any competent evidence to send and I'm focusing pretty much solely at this point on whether there was competent evidence of the fact of damages. And your position is even Mr. Weber's deposition testimony, first of all, we've got to make sure that was before the trial court. If it wasn't, then we shouldn't be considering it now as a basis to reverse. But if it was, your position is that wasn't enough because why?
Because the fact of damages, as you said, it's a higher standard. And in this case, you need to have, you would have to bring in experts who would actually come in and opine on whether or not there's a difference between.
So he couldn't, Mr. Weber himself, you don't believe was competent to do that. He could testify as to the measure of damages and its property value, but he couldn't basically give the causation linkage.
That's correct, Your Honor. You would need an expert to actually go through that analysis and to make it competent, admissible evidence for the court.
Counsel, did you make that argument to the trial judge? Did you say to the trial judge, it doesn't matter what Mr. Weber testified to as far as the effect of the notice of trustee sale on the value of the property, he's not competent to testify to that?
I don't recall that coming up during the discussion, Your Honor.
I mean, I don't know.
Yeah,
there wasn't
I
a trial,
remember there was a discussion about it by counsel for the counterclaimant, but and I believe it was wrestled through with Judge Reyes, and there wasn't a reason to readdress it.
It does. My recollection, and again, we'll double check the transcript, but everybody seemed to be focusing more on these appraisals. And my recollection is Judge Reyes' concern was, gee, these appraisals don't take in, as you know from the argument, Judge Reyes initially said, I'm going to deny the motion for summary judgment on the breach of fair dealing. And it seemed to me that the focus was more on, well, how do these appraisals show that the bank's conduct affected the value? And at one point, counsel for Mr. Weber actually said, I don't have any evidence of that, but then there may be evidence in the record.
Yes, Your Honor. In fact, I think there are two places where counsel, had basically made the admission that they did not have the fact of damages in the record. Our view is that again, the cause of that is you have to separate out, if the conduct, if you're going to claim conduct is causing you damage, then you have to show that conduct is actually causing you damage and not some other independent force, which, as we know, was really the market here.
So you're saying those can't work in tandem? To the extent that it's clear and apparent that the land values are collapsing, you're aware the land values are collapsing. Let's say arguably you had no intention of foreclosing the security. You can't look at those in tandem and say, knowing what you knew, that you generated a portion of the damages by not foreclosing and fixing the value at that time.
Well, Your Honor, I apologize, but I don't agree that there was never any intention to foreclose.
Let's just say in theory,
Okay.
hypothetically, if you were aware that the land values were collapsing and you knew that the property was shortly going to be worth nothing, do you then assert that the bank had that it doesn't establish as a part of the damage generated the bank's I'm not saying this well, and I apologize for that. That you don't believe that any portion of those damages is attributable to the bank for not proceeding with the foreclosure and the establishing a fair market and sale of the property?
That'd be correct, Your Honor. I think that's an independent, in other words, the general decline in the market is an
General decline?
Is it? Yeah. I mean, that's all we have. I mean, that, as far as we know, is that there was a general decline in the real estate market.
The bank didn't know about the appraisal showing that this market, that the values of this was declining?
Yes, Your Honor. And again, it depends where on the.
Did they know? Let me just ask the question more specifically, and I apologize. I shouldn't have been as summary on that. Did the bank know of the continued appraisals showing the decline in the value of these two properties during the period of time that it was continuing the trustee sale?
Your Honor, the appraisals they had were the ones that were conducted at the initiation of the loan, which were based on as I recall, that they would be finished with the capital infused by Mr. Weber and so on and so forth, and actually have certificates of occupancy, all of that.
And who authorized the other appraisals?
I believe at the time that's a standard procedure that the bank goes through when it
I mean, not that appraisal,
generates
the later ones.
Oh, the later ones were commissioned as exterior-only appraisals by Mr. Slavin's office. They were retroactive appraisals.
Okay.
Can you address Mr. Slavin's reliance on ARS 33814 and whether that affects our analysis on the damages issue?
No, Your Honor, I have to say it's the first time I'm hearing it today, but to address it on the fly, what I thought your comment is the appropriate response is that this is a separate claim for breach of good faith and fair dealing that they have initiated. They're not bringing the claim under the statute.
Well, it's the first time I've heard the argument too, and we don't usually address those for the first time at argument. So my impression was that statute would have applicability to the bank's claim against Mr. Weber, but I don't see any indication that that particular statute would establish the fact of damage on the standalone good faith and fair dealing claim.
Yes, Your Honor, and that is exactly, when it was being said, that's exactly what I was thinking, and you would respond the same way.
So you don't think that was raised below?
No, that was not raised below, Your Honor. In fact, it truly is the first time I heard it today. Your Honor, as far as I realize we focused primarily on the damages. I did want to point out that there are some other bases that I had laid out in my brief for justifying upholding the judgment as well. I don't know if the court is interested in talking about those issues. One was that when a party does materially breach a contract, there is a district court decision which has ruled that the breaching party doesn't get the benefit then of coming forth and claiming a breach of good faith and fair dealing. It loses that right when it is the breaching party. In other words, you're not going to you shouldn't reward the breaching party of that and give them a claim because of their breach. I think we have talked a little bit about the trustee sale statute itself. I will point out it does not require there's no limitation placed on it.
But doesn't that argument really, in essence, say, gee, if we act under that statute, we are immune from any bad faith?
Well, Your Honor, I think, trustees have to read the statute and abide. And, that's, it's clear in its language.
Right.
They could have said you have to renotice your trustee sale after a certain amount of time.
But nothing in the statute says, and the bank shall be immune from any action if it in bad faith continues the trustee sale.
It doesn't, Your Honor. I think, though, there should be some weight given to the statutory language and whether or not trustees actually follow that language. And I think also, Your Honors, I did want to point out, and I think it's already been raised, that Weber at no time was he prohibited from moving forward and selling his property.
Of course, he doesn't, that's right, but he doesn't make a good point in the argument that if he had done that and sold it, he'd be liable for the deficiency to the bank. And so why not wait until either the bank actually has the trustee sale and get his fair market value, and when then ultimately the bank never has the trustee sale, he brings a bad faith claim saying, why should I have to sell it? I mean, I could have tried, and maybe that's a mitigation of damage. Isn't that a mitigation of damages?
It is more of a mitigation of damages, Your Honor.
But in fact, with the lien on the property, he could not have entered into an agreement, absent some agreement with the bank, as to releasing its lien on sale if the amount of the sale was less than the amount of the lien, correct?
Absolutely, Your Honor, and that happens all the time.
Did the bank ever offer that?
No, it was never brought to us. I mean, he never brought a sale to us. If he would have come to us with, and the issue here is he just abandoned this whole thing, and then has just sort of thrown it back against the bank. And the bank, in the interim, I know we're not discussing, the reasons why the postponements take place, but they had some very deep concerns about getting involved in this property. It's almost like, I've been involved in other situations where a bank is looking at a property and then they find out there's environmental contamination. So what do you do? And you have to sort of work through those issues.
That all goes to whether there was bad faith.
Right, that goes to that issue, Your Honor. You're right, which is not really why we're here today. Any more questions, Your Honor? I'll finish up early.
Don't believe so. All right. With that, then, we are concluding the oral argument. As of this time, the matter is under advisement, and we will issue a ruling in due course. Thank you. We're adjourned.